Good morning. May it please the court, I'm Shay Moxon. I represent the appellant, Philip Schlichting. I'd like to reserve 5 minutes for rebuttal. We're here this morning on an order that dismissed my client's first complaint with prejudice. So the only way that order can be affirmed is if the court decides that there is no possible way that an insurance adjuster employed by an insurance company can be personally liable for the torts of breach of fiduciary duty or professional negligence, no matter what her conduct is.
The order, it doesn't go so far as to make a per se rule against a cause of action. It's just in this, as alleged, it doesn't state a cause of action.
Your Honor, I respectfully disagree. You're correct that the bulk of the order is critical of our allegations, but the language is in there. There's one line that says, because no Florida court has ever recognized the cause of action for fiduciary duty against an individual adjuster, plaintiff could prove no set of facts in support of her claim. Paraphrasing a little. Mm-hmm. That's reference to count one. That's a per se ruling. Then with regards to professional negligence, the court's reasoning was that insurance adjusting doesn't require a 4-year degree for licensure. That's a per se argument. Because that's true, we conceded that. Mm-hmm. We submit that that reasoning is incorrect. It wasn't a matter that we failed to allege that it requires a 4-year degree. We conceded that it doesn't.
Is there anything, is there a groundswell of case law from other jurisdictions that point us in the right direction?
No. I don't believe that really. I cited a case from South Carolina, Addison, which addressed an issue as similar to the 4th DCA's King case and said, well, this holding doesn't apply to an adjuster employee, you could sue them for negligence. But in both instances, it's not the same cause of action. Right. We're alleging different causes of action than negligence. So, no, there isn't. But if I could finish my last point, because I don't ever want to miss this, because this is important. One of the last lines right towards the end of the court's order is, because the court finds that it is apparent that plaintiff cannot amend his complaint to state a cause of action for breach of fiduciary duty or professional negligence, the court dismisses plaintiff's complaint with prejudice. That's on page 152 of the record. That is the per se legal ruling. It's also significant because it shows that the judge knows what the standard for dismissal with prejudice is and made the decision that there is no way this complaint could ever be amended, that in effect that nobody could ever plead these causes of action against an individual adjuster. So I admit the bulk of the order has to do with the sufficiency of the allegations, but those per se legal rulings are in there. And Judge Sisko consciously dismissed the complaint with prejudice based on that. And that's why the issue before the court becomes, can the court say as a matter of law that it is never possible for an individual adjuster to owe a fiduciary duty to an insured or to owe a professional duty of care merely because that adjuster is an employee of an insurance company when she's undertaking to handle this claim? I'd like to turn to count one, fiduciary duty. Now, a fiduciary is somebody who stands in a special relationship of trust or confidence to someone else. The cases we've cited have shown that it can come up in all manners of contexts. Fiduciary relationships are frequently implied in law, depending on the circumstances of the relationship or transaction. It can be implied in law when somebody undertakes to protect or benefit someone who's in a position of dependence, or when they're bound to act in good faith and with due regard for their interests, or when they're under a duty to give advice or act for someone else on matters within the scope of their relation. And the courts, in the various cases that myself and counsel have cited on fiduciary relationships, we've seen examples of a pastor, church that employed the pastor, real estate agents, loan officers, well, banks that employ the loan officers, psychotherapists, in one case even a daughter-in-law who is acting as her mother-in-law's employee. All these cases say that implied fiduciary relationships arose in all these contexts. So it's not a simple cut and dry thing that you could just say, this occupation never entails a fiduciary relationship. It depends on the facts and circumstances of the relationship between the parties and their transactions.
What's the special relationship with the adjuster? The insured has a relationship with the insurance company, yes, and expects that the insurance company is going to do right by him or her or it.
Yes.
And the insured, I am assuming, has absolutely no input in who the adjuster will be. If something goes wrong, the insured looks to the insurer.
Well, it's analogous to a law firm, I'd submit. A client frequently hires a law firm. They might meet with a partner, and then an associate works on the case. Well, every attorney who touches that case owes a fiduciary relationship to the client.
But that's because of the nature of the legal profession.
Well, it's the nature of fiduciary duties too. Like in the Doe case, you can see that it's entirely possible for both the employer and employee to owe a fiduciary duty to the client. Another case.
There are special circumstances alleged.
Yes, if they're alleged. And what we allege in this case is that the appellee, Ms. Fortner, she was acting in a fiduciary capacity to handle every aspect of the investigation, evaluation, and attempts to negotiate the FOIA claims fairly, honestly, with due regard for Schlichting's interests. Well, the undertaking of those duties creates a fiduciary relationship between the adjuster and the insured.
Well, that's no different than the carpenter undertakes to build a sturdy and habitable home.
Yes.
That translates into a fiduciary relationship, other than just some commercial undertaking?
Well, that is in that instance, it's not a matter of, it's possible, maybe under some set of facts. In the typical case, though, it's you don't have if the supposed carpenter undertakes to give advice to the client, to pick subcontractors, tells them, don't worry about a thing. I'm going to make sure that this house is going to turn out well and be leak-proof. It's possible. It's not the first thing that pops into your mind, but yes, it's conceivable. And that's why, I point out that it's arisen in all these different contexts. Yes, it's possible for somebody in just about any walk of life, if they're going to undertake to take care of somebody who's dependent upon them, to give them advice, to handle affairs on their behalf, that's when a fiduciary duty relationship arises. We allege that it arose. We allege that there are various breaches of that duty, and we've alleged damages. We've alleged all the elements of the cause of action, a breach of fiduciary duty. As Your Honor pointed out, Judge Sisko felt that we didn't give enough detail in our allegations. This complaint had the same level of detail as a lot of complaints we file, but if we feel it's sufficient, all the elements are laid out, the circumstances where, what the relationship was, where this fiduciary duty arose. If the court feels that some more things need to be spelled out, the remedy is that we get an opportunity to amend. already started to touch on the appellee's main theme of their argument that this is really a claim for bad faith and that should really be our only remedy for this situation. And what I'd say to that is there's nothing special about the job of insurance adjuster that you give that adjuster immunity for torts that they commit while on the job. Because we've seen that in other contexts. It's a long-standing rule in Florida that when an employee for a corporate employer commits a tort while acting on the job, they're personally liable for their torts, and it doesn't matter if the employer is also liable. That's not a defense. The Greenberg v. Post case, that involved an x-ray technician. Carey's Bromeliad Nursery, that's another one. There are various other contexts where they would be true medical malpractice. If a nurse or doctor is employed by a hospital, you can sue a doctor, you can sue a nurse. There's no rule that immunizes somebody for personal liability for their own torts just because they committed them while they were acting in the course and scope of their employment, except sovereign immunity, I believe. Every time I say that, I remember that. I don't know of any other one, and it is a general rule that they are not immune. Even in situations where the plaintiff has a contract with the employer, that Doyle case out of the 5th DCA I think is interesting. Although it says that the plaintiffs hired Doyle, the individual real estate adjuster, the very next line says that they entered into a written real estate brokerage agreement with his employer, the real estate agency. And of course that case concludes that the agent owed a fiduciary duty to them. And of course, again, the case of the law firm is analogous. Every lawyer who touches a case has a fiduciary relationship to the client. And also, as I pointed out in my reply brief, the Florida Supreme Court's decision in Wachovia v. Toomey, I think, is interesting because it shows that just because a claim of breach of fiduciary duty is not only very close to, but they said effectively the same as a bad faith claim, doesn't mean it can't go forward, even when it's alleged against a party that's not an insurance company. In that case, it was a claim of breach of fiduciary duty against an insurance broker that surreptitiously removed coverage from the insurance policy while the client had a claim pending against them. And the issue before the Supreme Court was, is that claim of breach of fiduciary duty assignable? Their answer was, yes, this is assignable because this is, in essence, just a bad faith claim. So I submit they never would have answered that question if there really is this idea that if a claim of breach of fiduciary duty is the same as bad faith, that somehow constitutes a complete defense. That means you can't bring it. And of course, it doesn't matter that there's no contractual relationship directly between the client and the fiduciary because fiduciary relationships can be implied in law without a contract. Also, there's kind of implied throughout the appellee's brief was this notion that if there's a failure to settle a claim that results in an excess judgment, that the only possible remedy is a suit against the insurance company for bad faith. And I've given examples that show that's clearly not true. One of them is particularly relevant is Torres v. Nelson. In that case, the insured first attempted a bad faith suit against an insurance company, lost. Then they filed suit against attorneys who were staff attorneys of the insurance company that were provided to defend the insured in the underlying litigation. They filed a malpractice suit against those attorneys for failing to settle the case. And that was dismissed, or the trial court granted summary judgment. The third district reversed, said that that suit could go forward. Another example is Bill Ayerly Insurance Company. That wasn't necessarily a failure to settle, but it was an excess judgment case. The insured brought a suit against an insurance agent for negligently failing to report a claim to the insurance company. That resulted in an excess judgment, and the court held that the excess judgment was a measure of damages available. You know, all just to show that there's no rule, per se rule, that the only possible remedy for a claim that isn't settled and that results in an excess judgment is a bad faith action.
Mr. Moxon, you're in your rebuttal time.
Oh,
Use your 5 minutes as you wish.
okay. If there are no other questions, I'll thank you.
Thank you.
Good morning.
Good morning.
Dan Martinez for Allstate. In this type of case dealing with an adjuster, we've got very specific duties that have been longstanding and recognized that and only arise by virtue of the policy of insurance. And you've got to go back all the way to Shaw in 1938, of course, to really get into the public policy issues as to why the judge's ruling in this case was correct. In Shaw, the primary thrust was that an insured, in turning over control of the defense to the carrier then owes a fiduciary duty for obvious reasons. But that control is what makes this decision correct, and it's at the essence of it. In the case of an adjuster, the adjuster doesn't control whether there's coverage, whether it will be accepted or denied, doesn't control the money, doesn't have the checkbook, doesn't pay it directly, doesn't get the benefit of the premiums. There are some out-of-state cases that touch on this that we cited in our briefs. The Sanchez case out of California and Natividad out of Texas. And they discuss these very concepts. And the idea that the adjuster is merely discharging a duty that's already owed by the carrier. And therefore, there is no duty that's been undertaken. There's no special relationship that's there apart from the insurance contract and the carrier. And for those reasons, an adjuster should not be held liable for a duty which the law has imposed for many years now on the carrier itself.
I suppose, I don't know what it would be, but you could dream up a set of circumstances where if what the adjuster is doing is independent of the insurance contract, there could be liability for the adjuster.
If it is an intentional tort, that is my reading of the law. But where it sounds in simple negligence, the law, as I understand it currently, given the precedent, is that there is no cause of action. And the question isn't whether there is a fiduciary duty owed. The duty is certainly owed by the carrier. The question here is whether a third party who the adjuster's never met can sue the adjuster for breach of the duty that the adjuster is carrying out on behalf of the company. One of the problems with the argument of my brother is that if we are to accept it, then there is no reason to have bad faith for carriers. And the reason is if you get to professional negligence, now you're talking about negligence, not bad faith. And if you can get that lower standard, there would be no reason to ever go after the carrier for bad faith. You could just go and try to prove simple negligence. It's one of the reasons, as a practical matter, that we're seeing more and more professional negligence cases brought against the lawyers themselves. It's an easier standard. But in terms of whether you can ever dream up a situation, you can, but it has to be intentional, and that was not alleged in this case. But I think if they can allege an intentional tort separate apart from the contract or the duties that were already there, then I would have to acknowledge that it would be viable.
Would you suggest then that the trial court's order goes a little too far in dismissing with prejudice?
I think if there was any set of circumstances where an intentional tort could have been alleged, I would have to agree with that. But we had 8 months of discovery between filing and dismissal, and at no time was any such allegation brought up. If there aren't any specific questions, I can get into some general discussions about whether or not an adjuster is a professional. There have been some arguments that that is an unsettled area of law. We disagree. If you go back to the Garden case, the idea was that the Supreme Court wanted to come up with a bright line test, and in Pierce, which they cited to, they were upset with the legislature because those guys weren't going to do it. And they suggested, you need to define this for us, and the legislature did not. And therefore, the court said, for purposes of the statute of limitation, we're going to have this requirement that if licensure requires 4 years, then they're going to be a professional. In terms of whether or not you can extend that reasoning to our situation, it's our argument that you must, just for purposes of judicial harmony. If you only apply that to the statute of limitations, then I believe it's a misreading of the Garden case. Garden says, look, in the absence of, what we don't want to do is disturb prior precedent on who is a professional. So the court said, in the absence of a statute, regulation, case law, that defines what a professional is, this is what we're going to say it is. And that's what we posit they meant by that. Some courts have read that too narrowly, particularly one court in the Middle District. It's the only one that stands by itself as reading that to say that you cannot apply it in any context other than the statute of limitations. But that's belied by Judge Poston's dissent in the Tiara case, which came later. And of course, the Middle District didn't have the benefit of. But in Tiara, Judge Poston said, look, this broker doesn't need a 4-year degree, therefore can't be a professional. And we don't see any other law out there to the contrary. Therefore, the reasoning in Garden should apply equally as to whether or not this person's a professional. So in the absence of some other guidance, that is the definition that should be used. And that's the definition that this court has adopted in the Hoskins case. One of the issues that can blur the lines here is whether or not qualification as an expert necessarily can qualify you as a professional subject to liability. And the Hoskins case discusses that and says, look, you can be an expert. You can certainly have expertise by your training and your experience and so on and so forth, and you can be an expert in court, but that doesn't make you a professional. To get to professional, we get to the bright line test that was enunciated in Garden and which has not been overruled. And Judge Poston, in his dissent, makes that clear, that that's still the law in Florida. So we can't have simple negligence. There's clear precedent on that, which obviates the fiduciary duty argument, is our opinion, or excuse me, our argument. And you cannot have professional negligence in this case. That brings us back to what's the remedy? It's bad faith. It's already there. The purpose, well, the practical effect of being able to bring an adjuster in is to defeat diversity jurisdiction. Most of these cases get removed, many of them, and if they're able to bring in any adjuster under this theory, that will then undermine all the jurisdictional law that's been created that protects litigants in cases like this. Unless you have any specific questions, I'll yield the remainder of my time.
Thank you.
Thank you, Mr. Martinez. Mr. Moxon?
The main thrust of Mr. Martinez's argument is that the duties at issue can only arise out of the policy. That's not, I disagree with that. For one, the adjuster's code of ethics itself imposes duties on the adjuster that are independent of their obligations to the employer or any terms of the policy. It states they are engaged in the public trust. It requires them to refrain from handling the investigation, settlement in any manner prejudicial to the insured. It also talks about they have to ensure settlements are fair to all parties. So adjusters are under ethical obligations that extend beyond the contract. And he also stated that they never met. Well, for one thing, the record doesn't show that, but it's possible for fiduciary relationships to arise even between parties that haven't met. For example, the Doe case, there's no indication that the plaintiff ever spoke with the bishop, who was one of the defendants. And Mr. Martinez also complained about changing the standard to simple negligence. Well, we have an alleged simple negligence. Maybe that can be considered in a different case when it comes up. But we've alleged different causes of action. He mentioned that we're seeing a lot of professional negligence suits against attorneys now being filed instead of, or it's frequently together with bad faith suits. Well, those are valid lawsuits, and they're succeeding. And I gave you the name earlier, the third DCA case, that's perfectly valid. And I'd also mention that some of these policies, these concepts, especially the ones recited in that California case he's relying, they're essentially the same as the economic loss rule, which the Supreme Court recently announced is now pared back to the products liability context. This idea that if the plaintiff had a contract with someone, then all the duties and remedies are defined by that contract. That's the economic loss rule. The idea that, well, if somebody's performing a service that they were hired by a company to do, the example of the independent adjusting firm, and somebody who's not a party to that contract can't sue them, that was part of the economic loss rule. The Moore and Say's case talks about how this court dismissed a case basically on that essentially same reasoning, that the plaintiff didn't have a contractual relationship with the engineers who inspected the house. They only hired the inspection company. This court dismissed that, or upheld the dismissal of that case based on the economic loss rule, and Moore and Say's reversed that. And then after that, the economic loss rule has been completely pared back to where it only applies to products cases. Virtually all of my colleagues' arguments in some way are the economic loss rule in other terms. As far as this discussion of the Garden decision, he stated it's a misreading to interpret Garden as being limited only to the professional or statute of limitations context. This is an exact quote from Garden. We limit the definition of professional set forth above to the context of the professional malpractice statute. It's not our intent that this definition be applied to any other reference to professionals or professions elsewhere in the Florida statutes, regulations, or rules, or in court cases that deal with issues other than the statute of limitations here. And that first sentence, when they said the professional malpractice statute, it's evident from earlier in the context, they're just talking about the statute of limitations, 95.11. So Garden limited it itself to the statute of limitations context. And Rocks from the 4th DCA also held that Garden is limited to the statute of limitations context, and they said we take Garden at its word. It only applies to statute of limitations. Do I have any time left? I believe I've covered everything.
About 10 seconds.
Well, are there any questions? Again, the issue before the court is it absolutely impossible to state these causes of action against an adjuster just because she's an employee of an insurance company. The answer is no. The court should reverse. Thank you.
Thank you, Mr. Johnson. We're going to do a marathon session. We're going to take our last case on the docket this morning. Bosher, if I'm pronouncing that correctly, et al. Versus AMT.